Josh, I just want to ask by saying, what's your reaction to all this?
So far, I'm very pleased at the professionalism and the high end of lawyering that we're seeing, especially with something so dramatic. This has been a very clean trial so far with very professional actions being taken by the court as well as the litigants, even with respect to exactly how high stakes this is. Because I know we're here in Atlanta and this is an Atlanta area case. This is way more than just an Atlanta area case. This case is literally being followed from coast to coast by people, both in the true crime universe, but also in academia and politics, because how this prosecution brushes up against our Second Amendment rights. And that conversation continues to evolve and expand as we see very strong evidence from the state that the last best person to stop this absolute massacre tragedy that allegedly was committed by young Colt Ford when he was 14, 15 years old, in murdering students and teachers and injuring so many others. That person that could have stopped it, according to the state, was his father, Colin Gray. And the state began this case by emphasizing how they wanted the jury to focus on Colin Gray's actions, not Colt Gray. This isn't a trial about what Colt Gray did. That's for later. This is going to be all about Colin Gray and what he did, which allegedly violated Georgia law.
Yeah, certainly. And I kind of want to walk folks through what we've seen, because it feels like every day we walk back into court, we hear this powerful, emotionally charged testimony, the evidence, the videos that are at times very, very difficult to watch, even not being connected to this case as a juror, as a witness, or otherwise. Walk me through what we saw out of day one, day two, and then kind of the transition of what it felt like going into day three, now day four.
Yeah, so what we've seen, the state is trained, and it has been proven time and time again in how to present cases to juries using a linear logic format, as well as painting as much of the associated picture as possible, contextualizing the scene, knowing full well, just like you talked about, Maria, this case has digital forensic pictorial video evidence that is traumatic. There's no way around it. There's been a lot of argument over too much evidence from the defense, trying to stop evidence being used purely for inflammatory purposes, and the judge has agreed with a little bit of that. But the state still has its right and has exercised it thoroughly in presenting the appropriate evidence of what happened and how it was connected to Colin Gray. So we saw for those first couple of days so many witnesses coming in and describing the scene. We talked about exactly what happened. The jury has a very good idea from a storytelling point of view of how the day began, what happened during that day, and then, of course, the horrific conclusion with so many people being injured, so many officers being dispatched, and the tragedy involved. That picture has been made, and there was very little the defense could cross-examine on without taking the risk of offending jurors. So the defense has stayed mostly hands-off, with some witnesses not even being asked a single question. And that allows the jury to understand the state's role, and it gives the state room to establish the foundation of their case. Now we are seeing the change with more discussion about what the interactions between Colin Gray and law enforcement looked like. Was Colt Gray present? Why were people noticing Colt Gray and his issues? We heard some very good testimony this morning on behalf of the state involving his absentees and the policies of the school, when the school is going to kind of perk up, send up a red flag, reach out to those parents, what proactive actions the state took through its various agencies and individuals in order to highlight the problems that we all now know Colt Gray was suffering from, because that contextualizes what Colin Gray, in the eyes of the state, then didn't do, which is prohibit his son from having access to firearms. And we're going to get more and more into the gifting and the provisioning of the firearm to Colt Gray, which is obviously the very heart of the state's case.
Yeah, certainly. And let's get into that. I did want to kind of highlight the firearm. It seems to be central to this trial. It was presented and viewed to the jury the other day. And really, the state is saying this is what set everything in motion, that there were 3 years worth of warning signs, they're arguing, and still this firearm was gifted with, as the state says, the knowledge from Colin Gray that maybe this wasn't the best idea for his son's mental state, and some of what came forward in warnings from schools, warnings from the FBI, and other places to him. So it kind of bodes the question of parental criminal negligence or parental responsibility in preventing a tragedy like this.
Absolutely. And the power impact of presenting that firearm in open court can't be understressed. For those who are familiar with firearms and comfortable and have been exposed to firearms, modern sporting rifles, AR platform rifles are part of the regular existence of firearms. They've become immensely popular due to their modularity, their standardization within military police forces that's come over into the civilian market. And AR platform rifles are sold by literally the millions because the only registered part of that firearm is going to be the actual action. It's the heart of the gun, the chamber, the actual firing mechanisms, not the trigger, but the actual firing mechanisms. And that is something that is powerful for the state because mostly the people that aren't familiar with firearms. If you've not held firearms before, if you've not worked in and around firearms before, it's a really intimidating piece of machinery. They're heavy, they're cold, they are sturdy because most of them have been over-engineered. This is a tool with one goal in mind, to accurately put bullets down range. That's why it was created. It doesn't have the fluffiness of a sports only rifle or the classiness of a single shot shoots in or something like that. No, this was designed for modern military and defense applications. And it's the first time some of these jurors are probably being exposed to a firearm. That's powerful. You just can't stop that. Now, we're also paying close attention to the language being used by different groups because we all know that the nation looks at this case as a Second Amendment issue. That's really what they're taking away from this. How is this going to affect fundamental constitutional rights in the context of it being a southern state and child access to firearms and school shootings? This is a kind of perfect storm of salacious, interesting, modern issues that are being discussed right now because of the prevalence of these firearms. And the reason the world's watching this is everybody who owns a firearm should be concerned because this is the first time in Georgia and second time nationally, someone is being prosecuted not for what they did with that firearm, but for entrusting or making available or providing a firearm to that third party. And what that third party then did now creates criminal liability for the ostensibly innocent third party, i.e. dad. But the state's pretty clear. They don't believe he's innocent. And they've got lots of evidence that Colin Gray ignored reasonable, rational, appropriate warnings from multiple groups, yet still ignored those warnings and provided his son with the ultra-hazardous instrumentality that he then allegedly used to commit a massacre. And it's interesting watching this language because you'll hear them talk about it being an AR-style rifle. They're not calling it a modern sporting arm, which is the preferred nomenclature for the gun universe. They don't like the idea of a black rifle or an AR. The AR is kind of the least offensive way of talking about these rifles. But clearly, the words really matter for the national perspective on this case, as many people believe this is an attack on the Second Amendment.
Yeah, and talk about a consequential trial that we're seeing play out here. We heard so much of week one was the prosecution taking the floor, presenting their case, calling their witnesses, and making sure that by the time they reach their closing remarks, they have the jury on their side. And we have yet to hear more from the defense on where they stand in their position and kind of undermining some of the arguments from that prosecution. You mentioned the evidence that they're pushing forward full throttle to this jury. What has been the most impactful from what you've seen so far in terms of the evidence presented?
It's hard to say that there's a specific one piece as much as it's the totality, the repetition, the overwhelming nature of the evidence. No one's giving conflicting reports. This isn't a case of he said, she said, hey, jury, decide which one of them is lying. In fact, I don't believe any of the testimony has really been pushed back at all, since it's almost stipulated that most of these events occurred, and it would be a loss for the defense to push back on minor issues that really are inconsequential to the overwhelming important parts of the case. Now, in other cases, it benefits you as a defense to fight every single tiny issue. This isn't that case. So the defense has been kind of neutered and has smartly accepted and leaned into that by not pushing hard during the state's portion of the case, which exactly means, like you're talking about, Maria, can't wait to hear what the defense does. That we know a little bit from their opening that this was the state putting dad on trial for giving his kid a gun. We know some of these theories of constructive responsibility are going to be explored, but we haven't heard the full-throated headline argument. Colin Gray's not guilty because X. And I think we're going to see that be developed, but it could only come out after the state has taken advantage of their position in getting to go first, because you can only defend against the allegations presented to the jury. And the state so far is presenting a straightforward, honest case, knowing that this is going to go up to the Court of Appeals and Georgia Supreme Court. If there's a conviction or not, it still probably has a high likelihood of getting appealed. And therefore, the record and the cleanliness, the tightness of the state's presentation is extraordinarily important.
Yeah, high stakes and every word matters here. Let's talk about the appeal potential here. You say it's likely and almost arguably inevitable that this is the next step, despite if there's a conviction, of course. What prompts a legal team defending Colin Gray in this matter to both try to argue in the present trial and also set themselves up for as much of a successful appeal as they possibly can?
Well, it's mostly, you're right, on the defense to set up that appeal, because in all likelihood, an appeal would flow after a conviction, which is guaranteed in Georgia law. If you get convicted, especially major crimes, you get to go do a direct automatic appeal, no questions asked. Someone gets to review your trial to make sure it was done properly. Now, the defense has some of the most experienced, professional, and just top shelf lawyers in the state. Jimmy Berry has appealed and been appealed hundreds of times. So he knows what a good transcript is supposed to look like. He knows very well what the Court of Appeals and Georgia Supreme Court justices are looking for and attached to if they're going to be willing to really change things using their power. Appeals, most of the time in an appellate presentation, the aggrieved party, in this case a convicted defendant, is going to say, hey, here are 5 errors, 3 errors, 12 errors that happened during this trial. They're going to set out those errors, talk about how and why those errors exist, and ask the court for a remedy, which is generally going to be a reversal, a dismissal, or sending it back down for additional litigation, because the appellate courts are not trial courts. They can only decide appeal. So identifying what those enumerations of error are going to be has already begun. There are going to be specific enumerations of errors from actions within the trial, but then there are also going to be more academic enumerations of errors that relate to the actual charging documents, the arguments that are being made, that kind of stuff. So it really is a multi-track decision. And we know there's going to be an appeal. So the goal during the trial is, after you've kind of identified what your main appellate issues look like they're going to be, maximize those, illustrate those. We saw recently in the Faust case, where obviously the appeal is going to have a lot to do with the relationship between the defense attorney and the court. So the defense attorney did a very good job magnifying those interactions, which you just can't miss when they do the appellate review of the transcript. Similar here, they're going to be focusing on the specific arguments the state is making, logic or legally, as well as the evidence presentation and what testimony is elicited, to find out whether some of that testimony should have been inadmissible, was presented wrongfully, or was inaccurate. You're also going to call into question the decisions of the court. We are very happily sitting in front of Judge Prim, a very experienced judge. He's been around for a long time. He knew on the outset, as the court, to protect this case, he was going to have to work a little bit harder. So that's why we saw this jury change, where they selected a jury from a neighboring community and then are bringing them back to Barrow County for the actual trial. That's in order to foreclose a very apparent appellate issue, that is, the jury wasn't the right jury to hear this. And we see that analysis ongoing during the entire trial.
Yeah, certainly. It is interesting to me to talk to you about what's playing out here, because you do have, an extensive legal background, and so I'm sure your lens of the situation, you can kind of start to see which direction either side is guiding things in their overall argument. I am curious, watching trial this week, knowing what's still ahead, what have been the strengths and weaknesses from the state's side in their arguments?
The strength of the state is that they have a moral high ground, and they have enough law to make a very straightforward case. Using the statutes that the state has used wasn't an apparent pathway. They had to do some real thinking because of the novelty of this prosecution, looking obviously at the Crumbly case out of Michigan, looking at other prosecutorial actions nationally when it comes to third-party responsibility. So they put in a lot of effort to streamline their case, workshop it so that it is presented in a straightforward manner. And I believe they've done a good job slimming down their argument to make it palatable for a jury. Juries can engage and really get into the nuts and bolts, but it's easier for them when there's a big bright line decision to make. And the state did a very good job illustrating that at the beginning, where with its opening argument prefacing or predicting, hey, jury, you're going to hear from these people who are going to show you that Colin Gray's actions were the last opportunity to stop this. And when Colin Gray was given warning after warning after warning, he proactively ignored them. Not only did he ignore them, he actually violated and worked in opposition to that kind of warning by acquiring this firearm and gifting it at Christmas for the child to use, ammunition, letting it be freely accessible within the house, keeping the case short and small, while also doing a good job of illustrating the results of Colin Gray's actions, lack of actions, which was that massacre. And the discussion of the massacre, the proof of the massacre, I believe borders on overcumulative, but is still appropriate. I know the defense and lots of people who are supporting Colin Gray are very upset that there's been so much evidence and testimony involving the actual massacre, with the argument that that's irrelevant. We all know what happened. You could summarize that a massacre took place with one witness and not very long. The state chose to really kind of go into this. And I believe the defense is going to turn that around as much as they can against the state and make this about selective prosecution, make this into a political prosecution. It's very often the recommendation, if you've got bad facts, argue the law. If you've got bad law, argue the facts. And you're seeing some of that manifest with the politics involved in this case.
I see we have a guest joining us here. On
She heard
ANF
your lovely
Plus.
voice and was like, meow, I want to talk to Maria. So yes, one of the Justice Kitties has decided to join us. Being an unseasonably warm and beautiful day, watching the ANF weather, this is unseasonable to say the least.
Yeah, certainly. And if they have any legal analysis, they're more than welcome to contribute on this stream.
We'll get some meows and some purring, for sure. But yeah, this case, here's the cool part about this case. We know the horrorness of it. Like, this is kids getting killed out of school. These kids are my kids' age. These teachers are my contemporaries' age. This is in a community that looks exactly like the community I was raised in, and it represents a community that I think a huge number of Georgians are attached to. The suburban trending on rural, not downtown, but close enough to the city, but a nice community. And this case scares the ever-living bejesus out of every parent in Georgia, because as you're raising a kid, you get to that point where you give your kid to a school. And it's weird. You're there in kindergarten and you're like, holy cow, here's this child that I brought in the universe. I'm giving it to somebody else to take care of for a day. And that's why it's so hard in elementary school when you're doing those first separations. And then you get to high school and you're like, all right, my kid's turning into a person. They're allowed to make their own decisions. They have responsibility. They have independence. I can tell them to go do something and they do it. But at least they're safe because they're in a school. The betrayal of not having safety at school, that hits every single parent because you can't control it. You've got to trust the school. And while I love my schools and my teachers, I also understand it's a big organization run by the government, so it ain't going to be perfect. And that's a really frightening idea for families to bring home. And the state's doing a very good job linking that with the personal accountability and responsibility that the state insists is the law. If you own a firearm, you have to handle it, store it, make it available or unavailable in a reasonable, rational, responsible manner. Otherwise, you're going to be held accountable for what a third party does with that firearm. And I think there's a lot of support, bipartisan across the spectrum, for more accountability for firearms owners. We've argued in this nation for the better part of 50, 70 years that guns are a tool. Guns aren't bad. It's the people that have the gun. There's all these arguments about the physicality of a firearm, and it's been almost impossible for us to legislate that object in the streams of commerce. But what we can regulate, the behavior of people. And so rather than creating a firearms ownership list or background checks or et cetera, this is really the biggest step down the path of, okay, we'll regulate firearms by regulating the people that own them. And I could see a number of possible laws coming in Georgia as well as many other states as they consider this issue, criminalizing what could be considered lazy or ineffectual or dangerous management of firearms. All my firearms, except one that I would be using at that moment or carrying, stay locked up in a safe, along with the ammo. And there's, in fact, a Georgia effort to give tax breaks for the purchase of firearm safety materials, specifically like safes. Savannah and Glynn County had legislation involving the storage of firearms, specifically in cars, trying to criminalize because so many firearms are stolen out of cars. Half the reason cars are broken into at any one place is to root around and try to find a gun. So I'll be very interested to see how the political response to this prosecution manifests, not just in the South with a strong tradition of firearms protection and Second Amendment protections, but in the more traditional pro-regulation states such as Massachusetts, New York, and California, where I could see a whole new crop of laws be developed, literally being written while we're talking, saying, hey, rather than regulate the guns, whoever the owner is, we got free reign. Let's make it so that if you want to possess a gun, you're required to take these steps, own these things, comply with these actions, not regulating the firearm, but regulating the person's behavior when they're in possession of that firearm. And that's something that's pretty clearly lawful to do.
And, you know, we talk about how high profile a trial like this is, to the point that you did have to dip into another county to find a jury pool in this nationally watched case now unfolding. You mentioned the political climate and the political pressure. Could we see, or are we currently seeing, some of that influence the judicial process that's playing out in this trial?
I think it absolutely reflects on the seriousness in the way that both the state and the court are handling this issue, knowing that if this case devolves, if this case falls apart, or there's some unexpected explosion, it could, let me carefully parse, negatively affect the interests of a lot of people. Like, if this politically goes off the rails and devolves into an argument about straight up gun control, straight up Second Amendment issues, if the defense is able to reframe this case from being a murder case into being a case about the Second Amendment and politics, wow, you're changing the dynamic entirely, and it's dramatically going to affect the thought process of legislators and politicians nationally, because Second Amendment rights are so important. And if this turns into, if, say, big influencers picked up on this case and decided this was an overarching state effort to grab your guns and steal your guns, man, a couple of well-placed PR statements from big gun groups could absolutely change the demeanor of the nation when it comes to this prosecution. And we will see this prosecution turned into more of a political football, but I don't believe that will be until after the jury has done its job, because everybody on the spectrum is hoping for the right result from this case, be it a conviction or an acquittal. But right afterwards, we are going to get responses from across the spectrum, every single side. Very much, if there's an acquittal, you can predict that the pro-safety groups and more gun regulation groups are going to decry how powerless our system is to protect our most innocent and precious children. That even when the state sends out armed state agents to warn about known impending dangers, we couldn't do anything because they really couldn't at that time. Had the officers shown up and started to try to take firearms out of that house, oh my Lord, there'd be a riot in the streets. You can't just have officers showing up at people's houses and taking their guns away. Georgia would be burning in 30 minutes. And then you see on the other side of this some pro-law enforcement, pro law and order kind of groups saying this is the way the system's absolutely supposed to work, and we look forward to holding the owners of firearms and the providers of firearms responsible. System works. We don't need more laws because we already have a law that punished a man for allowing this to happen, and that should be the deterrent effect that we want. And now everybody in Georgia and elsewhere is on notice that you're responsible for what happens with your gun. And there's good arguments on both sides. Like, that's the thing. You can't just ignore the other argument and minimize it and dismiss it, because it's got really smart people who really care supporting it.
Do you think they're trying to make an example out of Colin Gray?
I believe that's certainly part of the calculus. The DA didn't have a lot of choices. The DA had one of the worst crime in county history by far. You've got the death of kids and teachers in a protected, safe, secure environment by someone who was invited to attend there, and despite multiple state actions and security, they didn't stop it from happening. So there were failures and failures and failures. He's the DA. He's got to go prosecute people when the law gets broken, and he is going to run roughshod over the young Mr. Colin Gray. Now, Dad, that's where he had so much more discretion. District attorneys in the state of Georgia are where the buck stops with how charges are brought, who gets charged, what they're charged with, and when, where, and how they're prosecuted. That is the power of being elected as a county top constitutional level prosecutor. And no one can really critique or criticize you, because that's why you were elected. And this district attorney, I think smartly decided to expand the prosecutorial rights due to the harm done to his community. And he wanted to go after anybody and everybody that he could that influenced what eventually happened. And I believe he would face opposition and certainly a lot of anger in the community if he had not pursued a case against Dad, especially after the Crumbley cases in Michigan proved that this was a valid prosecutorial effort that juries responded to with a conviction. And I believe he's probably going to be successful again here because this community is angry. And you got to feed that anger if you're a DA. Otherwise, it'll kick you out of office.
And we're talking with criminal defense attorney Josh Schiffer here, legally weighing in on the trial of Colin Gray. I'm glad you bring up the Crumbley case out in Michigan at Oxford High School, the tragic loss of 4 people and 7 of those injured at the hands of a 15-year-old Ethan Crumbley, and then his parents, James and Jennifer Crumbley, both being convicted for a similar situation, not doing anything about this massacre that their son carried out. And so I'm wondering for the prosecution if they're using this as a roadmap to bring forward a similar kind of justice in the Colin Gray case.
It would basically be professional malpractice if the DA's office hadn't reached out. And same on the defense. I'm rather close with Shannon Smith, who was at the top end of the Crumbley defense up there in Michigan. And I guarantee that Jimmy Berry and crew have reached out for them and certainly reviewed that process because that's where you're going to learn what worked and what didn't work. Now, the cases against the Crumbley parents are under appellate review up in Michigan, and everybody's watching that very closely because the convictions were clear. The state achieved its goals in holding mom and dad responsible for the actions of their son under this theory that the parents not only had noticed something was going on, but were the last, best, and only people in a position to stop it. And that brings me all the way back to something that, some of this audience barely remembers. It's 9/11. 9/11, and in the aftermath of 9/11 is where we got this national ethic of if you see something, say something. It's our communal responsibility to take care of the tribe, take care of the community by being responsible. And that increased our requirement that fellow members in our social contract actually take the right actions. Traditionally, the government couldn't force you to do very much except pay taxes and die. Now we're seeing this expansion of duties, of accountability, where if you see something bad that we know is bad, you have an obligation to do something about it. Sometimes even if that obligation is just walking away. We even see that in some of the Epstein stuff right now, where the argument for some of the kind of tertiary included members in the Epstein files is, hey, when you found out, why didn't you leave? Why didn't you cut them off? Why didn't you say something or do something? Not that the person including the files is accused of doing anything bad. Why didn't they do something to prevent, stop, affect the harms that were so apparent? And it's kind of the argument here. Hey, Dad, your kid has a shrine to a school shooter, Mr. Cruz in Florida. Your son's fascinated with these uncomfortable, dangerous issues, and teens will be teens and boys will be boys, all that other stuff. But it falls flat when you've got multiple visits from law enforcement. And that really is the key, makes this case the unicorn, is that the state did its job in coming out to visit the family, which raises the very interesting issue. Is this a law enforcement resources problem? What would have happened if this had been a more rural or more urban community? I tell you, having lived and practiced in the major metro Atlanta area for my entire career, there are a lot of communities where cops don't knock on the door and have polite conversations about your kid and go, no. If you live in some more challenging neighborhoods, that's not the way cops work. If they're knocking on your door, they're there to pick up your kid. The idea that they'd knock and talk and let the kid go in some communities is farcical. It just It never happens. Are you kidding me? Wouldn't that cop be afraid of getting sued? As they should be. And there's going to be an argument that the police officers that interceded earlier didn't do the right thing, and they were the ones that should have stopped this case. We're going to hear that argument in the defense, that if the state was that concerned, why would they just trust a parent when they got a guy with a badge and a gun and constitutional authority to do something? Why didn't that guy do something? Wasn't it that guy's job? And that's where we're going to get stuff like race injected, and it will get injected. We'll get into some class issues because that treatment by law enforcement of Colin Gray, of Colt Gray and the Gray family, that becomes a hard pill to swallow for jurors. If they sense that people are being treated one way versus another, or specifically targeted or given benefits, that really upsets jurors. Jurors want people to be treated the same because we're ostensibly all citizens. And you and I know that that's just not true, but we're still going to hold the system to the promises of the system. And the officers failing to take additional, more aggressive actions can be turned right around on the state where, no, this wasn't a Colin Gray problem. This was a state problem. Why didn't the school kick him out earlier? Why didn't the school get involved more aggressive? Clearly they knew about this. Letters are getting returned undeliverable. Why didn't somebody follow up on that? 7 unexplained deaths. Why did they just make a phone call? And that was kind of it. And you really can turn this around from the defense perspective and show that this is a scapegoat case, where really the only reason they're prosecuting Colin Gray is to cover up from the indefensible, poor job performance of our community leaders. And that in other communities, police would have done something. Police would have stopped this. The school would have stopped this. No wonder we had a shooting. We have these people in charge of protecting our kids, and they fail. Now that's not a fun discussion to have, but this is criminal court and a man's life's on the line. And Jimmy Berry and Mr. Hobbs will be very effective at asking uncomfortable, almost unanswerable questions when the time is right during the second part of the case.